All right, around 10:30 a.m. Eastern time today, Obamacare was in deep, deep trouble.
And in news, just in, a federal appeals court has dealt a major setback to Obamacare.
More breaking news. This time it concerns Obamacare and a dramatic blow by a federal appeals court aimed at health care tax credits.
2 hours later, however, things were looking up.
This breaking news now. A second federal appeals court has reached a conflicting opinion, another decision, in connection to tax credits granted through the Affordable Care Act.
Okay, so here's what happened. There were two rulings concerning the latest legal challenge to Obamacare, which is perhaps at once both the most ridiculous and the most threatening challenge the law has faced. The case is built on a single sentence in the law that authorizes health care subsidies for low-income Americans purchasing insurance. And that sentence says the subsidies, which, let's keep in mind, are the key to the affordable part of the Affordable Care Act, that those subsidies are available to people who enrolled, quote, through an exchange established by the state under 1311. That's the section of the law that sets up state-based healthcare exchanges. Okay, but 36 states are not using state-based exchanges. They're relying, at least in part, on the federal healthcare exchange. So, having lost every other fight to destroy the law, conservatives pointed to that line to argue that only those who enroll through state-based exchanges in the minority of states that set them up are eligible for the healthcare subsidies that are the key to the whole bill. If you went through the federal exchange, they said, you're out of luck by the letter of the law. No subsidies for you. Now, if that's truly the case, Obamacare basically falls apart, or at least it does in the 36 mostly Republican-run states that haven't set up their own exchanges. You need the subsidies to make the system work. Without them, according to one estimate, premiums in federal exchange states increased 76%. And more than half of the 8 million Americans who purchased subsidized coverage would have to pay more. In the first ruling today, a three-judge panel, two Republican-appointed members of the federal D.C. Circuit Court, which is one step below the Supreme Court, effectively argued that even though the whole point of Obamacare is to provide affordable health care coverage for all Americans, Congress never authorized subsidies for Americans who enrolled through the federal exchanges. In other words, they found that Congress, in that little sentence, they drafted a law that contradicted the law's intent. In the other federal decision today, this one from the Fourth Circuit Court of Appeals, a three-judge panel, all appointed by Democrats, came to the conclusion that when you're trying to interpret a law, you should assume the law was not constructed to render itself inoperable. One of the judges used a pizza analogy to make the point. If I asked for pizza from Pizza Hut for lunch, but clarify I would be fine with a pizza from Domino's, the justice wrote, and I then specify I want ham and pepperoni on my pizza from Pizza Hut, my friend who returns from Domino's with a ham and pepperoni pizza has still complied with a literal construction of my lunch order. Joining me now, Lawrence Tribe, constitutional law professor at Harvard Law School, author of Uncertain Justice, the Roberts Court and the Constitution, who has been banging the drum on this case. Two decisions today. Professor, who got it right?
Well, I think the Fourth Circuit got it right, and I think Judge Edwards, who dissented in the D.C. Circuit, got it right. But I wouldn't absolutely count on the U.S. Supreme Court to get it right, because I think there are four justices there, the same four who were prepared to invalidate all of the Affordable Care Act, who tend toward a literal reading of statutes. And there are four justices who tend to focus very much on what would make the law sensible. But the D.C. Circuit said that an unintentional drafting gap is enough to require a literal reading, even if it makes the law fall apart.
I want to emphasize something I think is important here. In the last challenge we had about the mandate, the constitutionality mandate, there was at least a kind of principle at stake, perhaps, about whether the government could compel you to do this thing and whether it was tax, all sorts of constitutional issues at stake. There was an ideological content. There is no ideological content here. I mean, plaintiffs are arguing these idiots screwed up and 8 million Americans should have to eat it, basically.
And there is, in a way, a constitutional principle at stake, because if you actually read the law that way, then a number of people, it's unclear how many, but the Fourth Circuit says quite a few people, may end up having not only to eat it, but having to pay a penalty if they don't eat it, and at the same time not getting the money that they need to afford to buy it. That might be unconstitutional. And one other theory seems to be that what Congress was trying to do was perhaps put pressure on the states to create their own exchanges, and do it by holding people in those states hostage. If you don't create an exchange, the people in your state
don't get the
who
subsidies.
are lower income don't get the subsidy. That might be an unconstitutional form of pressure on the states. So in a way, the very same kind of practical reasoning that led Chief Justice Roberts in the earlier knockdown round of Obamacare to say that he would interpret the law as a tax, even though that required a bit of bending, might lead him to say that he will interpret the unintended gap in this law as though Congress had written what it meant to write. And I think that's what ought to happen. But if it does, it's likely to be 5-4. So it's going to be another cliffhanger in the U.S. Supreme Court.
So next, this case right now, you've got one circuit, D.C. Circuit, saying one thing, Fourth Circuit saying another. The D.C. Circuit was a 3-judge panel. It could be heard what's called en banc, right, which is the entire D.C. Circuit. And there's an interesting wrinkle here, which is that D.C. Circuit looks very different than it did a year ago, because after Harry Reid engaged the nuclear option and got rid of judicial filibusters, this White House was able to put a number of people on that specific powerful court just in the past year that changes the composition. How does that affect how this might play out in the next round?
Well, it's partly going to be up to the Solicitor General. Is he going to ask the full D.C. Circuit to consider the case before the losers in the Fourth Circuit, the ones who wanted to rip Obamacare apart completely, go straight to the U.S. Supreme Court, which is what they might do? So it's really very hard to plan out exactly who's going to get where first.
Let me be also, just to go back to this sort of bad faith. The bad faith of this really does bother me, actually, I have to say. Even as someone who likes sort of interesting legal issues. Let's just be clear. There wasn't a plaintiff walking around who was like, I am being injured by this misconstrual of the statute, right? I mean, this was just brought by people that want to destroy Obamacare.
No, well, they actually did find people with injury.
Of course, right.
They found people who had some dollar injury, and that was all it took in order to get standing. But clearly, the purpose of the suit was to dismantle the Affordable Care Act. No one doubts that. But that isn't so different from lots of ideological
Impact litigation. Lawrence Tribe from Harvard Law School. I really appreciate it. Thank you.
Thanks, Chris.